Liberty Fighters Network.
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 Liberty Fighters Network. Liberty Fighters Network.
Good day, liberators and fellow South Africans. Some of our supporters might be unhappy about what I'm sharing with all of you now, but people, you've learned by now that both Liberty Fighters Network and myself are WYSIWYGs. What you see is what you get. We're not hypocrites. What we say, we do, and what we do, we say. We've proved ourselves over and over again that we stick to our guns. We stick to our arguments, and we're not apologetic about anything that we do. And people, my big mouth have landed me in a lot of trouble before, and some of you might recall the Supreme Court of Appeal, which has opened a criminal case for contempt of court against me for alleged utterances I've made towards the court that they believe were allegedly contemptuous, and I'm actually looking forward to that trial proceeding. And yes, I would like cameras to be there and a lot of supporters when that commences. But leave it as it may. What I'm going to share with you now, people, I've thought a long time about this, whether I should or should not, but it has come to a point now that the public must know. I need to share my information with you, and you must make the informed decision yourself. You must create your own opinion. I'm just simply showing you proof, and you might come back to me and say, but well, there's other proof showing in a different direction, and I will consider that again. But and people, I don't know how long this is going to be, but this is very important that people should know, and this must be shared with others so that others can also make an informed decision. And before I start, I just want to make a few statements. Firstly, yes, this video is about the organization called DearSA. I truly believe that DearSA is a legitimate organization who wants to have the best for the people. Secondly, the chairperson, Rob Hutchinson, I've met him once, communicated with him a couple of times. Very decent person, very nice, very intelligent, very sincere. So Rob, you're a very nice person, and people should know that. And then I want to make it clear that Rob, up till date, and I'm not aware of anything to the contrary, has not been found guilty by any court up till now of financial irregularities. So he's still innocent before and not found guilty on any accusations. But I need to share this. I've given DearSA's attorneys, Hurtig attorneys, an opportunity before to respond over since December 2020, and it has escalated to more and more things happening that I'm not happy with. It has not been rectified. Recently, Rob stated in public and in the media that the government allegedly said that organizations like Liberty Fighters Network and DearSA are terrorist organizations. I've asked them numerous of times to present me with a proof. Neither Hurtig attorneys nor DearSA have provided me with any such proof as yet. So it's only claims. But let me show you why I'm a bit disgruntled, and you as the people must know about this. Download this video if you don't have a lot of time. If there's going to be a lot long video, download it, watch it at a convenient stage, because this is very important and needs to be taken note of. Let me start off with an email or a newsletter that DearSA always send out to their participants, and I'm also a recipient of that. It's dated likely the 16th of August, and it says, "Dear Reyno, we've had a fantastic response from DearSA participants. They basically thanking the comments that were made and also the donations that DearSA received. And Rob here, or DearSA, refers here to a pending court case brought by DearSA in May 2022, which reviews the government's introduction of new health regulations." And then he goes on to say or state that when DearSA first brought its court case on 9 May this year, one of its arguments was that there had been insufficient time for public comment. The government then extended the period for public comments to 5th of August. Since then, it has received over 320,000 comments, which is a huge response, and more than 97% of these are against the regulations. Well, firstly, the problem that I've got with this email is that it only mentions DearSA as the so-called applicant in the 9 May court application against the government. DearSA is not stating, as a so-called independent organization, I need to add, that DearSA is actually the second applicant. The first applicant is Afriforum. Now, people, Afriforum, Solidarity, by now, everyone should know that Liberty Fighters Network and these organizations are not sitting around the same table for obvious reasons. And the most obvious one is that that Solidarity used to have been called the Mijnwerkersunie, which was a creature of none other than the Oppenheimer family. Yes, the infamous Oppenheimer family, the mining moguls of the world. And it has changed its name to Solidariteit, Werkersunie, and then later on, now it's just Solidarity. And Solidarity created Afriforum. And Afriforum is an organization which stands for the rights of Afrikaans-speaking communities like myself. But sadly, a lot of things that Afriforum has done, according to me, is actually showing that they're not very much after protecting the rights of the Afrikaans-speaking communities. They love to get a law firm like by the name of Spies to take the one after the other case to court on the basis of so-called human rights violations. Very sincere, but people, they tend to fuel also the issue about racial divisions in South Africa, it's always about color and race and minorities and majorities and people. I think by now the people in South Africa are fed up of being aligned according to racial, cultural, traditional divisions. We accept by now that we are one nation. We are, and each one has got its own characters, and we just need to respect one another. We must go out of the way from aligning ourselves with a race or a culture or even a language-speaking community. So Liberty Fighters Network is totally against that. But the fact is that now the second thing that DearSA is not sharing in the correspondence to some probably over 900,000 people is that there are three other cases that has also challenged the health regulations in some way or another. Firstly, it's Liberty Fighters Network, which have actually lodged our application 3 days earlier on the 6th of May. And then there is also Solidarity in another case, and then other one, Sakeliga. Now, Sakeliga as well is actually a creature, or has it's got its origins from Solidarity, just like Afriforum. So why would three different applications be lodged by organizations coming from the same embryo, from the same origins? It's strange, but DearSA have aligned itself with Afriforum, and it's not the first time that this has been happening. And people, let me just show you this, that Spies attorneys has been also previously used by DearSA, and let me just show what Spies attorneys is saying for themselves. It's coming from their own website, and Spies attorneys says that it's coming from the own hurterspeech.co.za, and it says here that that in April 2009, this part, in April 2009, Spies was re-elected as Member of Parliament. So he has come from Parliament, but shortly afterwards decided to return to full-time practice as an attorney with a particular focus on civil rights litigation with Afriforum as most prominent client. Since then, the firm has acted on behalf of Afriforum, Solidarity, and various other NGOs and think tanks. So Hurterspeech is basically the attorney firm for Afriforum and Solidarity. And now DearSA has joined as second applicant in an application for Afriforum as the first applicant using their own attorneys, Hurterspeech attorneys. So I am concerned that people now, DearSA as an independent organization, is asking the public to fund their case, but they don't mention Afriforum. So technically speaking, DearSA is collecting donations from the public for Afriforum's case as well, but it's not said. And people, I doubt whether from this 320,000 comments, or how many DearSA received, whether all of them are supporters of Afriforum. I honestly believe that the comments came from a diversity of people supporting various different organizations and political parties and with different beliefs, which have commented on that. And if they would suddenly know that Afriforum is now also paying the Hurterspeech attorneys, which is the attorneys for Afriforum, and Afriforum is the first applicant, I honestly don't know whether DearSA would have succeeded in getting such many donations then. So there's a deceit in their marketing. So that needs to be addressed, DearSA. And then let me show you a video of DearSA. It's on their own website. You can download it there and you can watch it there. I'll go to their website just now, but I want you to listen to some things that Rob is saying here. And let's start off.
A platform which is sort of a middleman between government and the public, and creates an interface where the public can directly communicate and influence the outcome of the policy.
So in this video, Rob says that DearSA functions as a middleman between the public and government. So when you use their platform, all the comments that people make are then collected by DearSA and then from there on sent to government. And that's a very interesting process. And let me just go on and with this video that I've just showed you, with where Rob says basically how they operate. And I've got some opinions about this.
There's a number of successes that we've had. Number one was we influenced the outcome of the drought charge, which was attempted to be implemented by the City of Cape Town way back in beginning of 2018, I think it was. The administrative law says they have to put it out for public comment. We discovered it, built the platform, informed everyone, told them what it was about, and created that mobile platform where they could provide their input within 2 minutes on their cell phone. And we took the public participation from an average of 200, which the City of Cape Town was used to getting, to 61,000 on that.
People, I've stopped it there. An average of 200, and now it's up to, 60,000 or so. It sounds very much sincere. But people, when you watch this further part, you're going to see something that I've just thought, oh my golly wally, what is going on here? Let me continue with that.
A very important one is the amending of Section 25 of the Constitution to cater for expropriation without compensation. We ran, when government launched that last year, we ran the only non-biased process. Every other organisation ran petitions DearSA Africa doesn't hold any view. We encourage public participation, and we captured about 230,000 comments from the public, which was directly to Parliament, actually printing them out and hand delivering all the comments to Parliament, as well as an electronic summary of what we did.
People, there's a couple of things I want to highlight in this video. Firstly, Rob said that they don't hold any view. DearSA does not hold any view. So is it acceptable for an organization like DearSA to solicit comments from the public, and then based on what I've showed you earlier, a 97% that's against health regulations, they decided to partner with Afriforum, which is a organization holding views, and very, very drastic views, and then to put before court acting in public interest, because 97% of those people that commented didn't want the health regulations. It sounds very noble, but people, what about the 3% who said, well, we're happy with it? Now, they have commented on these health regulations, saying that, well, they're happy, and DearSA is supposed to be an organization which is the middleman between them and government. So they want DearSA to submit their opinion, their comments to government. But now suddenly DearSA has partnered with Afriforum, and they are challenging the health regulations. We are also challenging it, but we are doing it by principle, because our goals are aligned to what we are doing. But DearSA is not supposed to hold any opinion, and that is a problem. And people, the other problem that I've seen, have you seen those stacks of comments that Rob showed us? Imagine 200,000 pages or so suddenly land on the doorsteps of Parliament. And those are comments for new legislation, for draft new legislation. People, do you really think that government will read through each and every one of those pages? Open each and every box and read through them? If you really think that our government will do that, then you've got a lot of hope in our government. But I honestly think that, as a reasonable person, that once those boxes arrive on my doorsteps, I will just say, oh, you know what? Let's use this for briarwood and make a nice bonfire. That is what the government is doing and has been doing. Don't think that they would suddenly employ additional people to go through each and every one of those. Even if DearSA provides a summary of all these cases, then eventually it lands up, like in our very case, that government is presenting a record to court which is so strange that it's millions and millions of pages that needs to go through in court, in a normal motion court process, which is totally impossible to do. Even if the health minister was a speed reader and a highly intelligent person, and I'm not saying that he is or he's not, he would not be capable of going through all of those comments. So people, I just wonder whether DearSA has not taken their responsibility as the intermediary between the public and the government a bit too far. In the fact that those comments might be seen by government and as spamming. People, if people have sent their comments individually, and I will show you how submissions are made. Individually, you've got control over your own process, and you will then receive a read receipt from government that your submission has been filed. But with DearSA, you take 2 minutes, you say, yes, I'm in favor or I'm not in favor of these new regulations, but then government has got a point. They have said that this process of commenting on draft legislation is not a referendum. It is not to say that you're in support or not in support of a certain thing. It is to get the input of the public and of organizations which really can produce proper input of value to try and guide them in the right direction. As Rob said, 200 on average before, and then suddenly it escalated to 61,000 that have been forwarded to the Cape Town municipality government, local government, to influence. I don't know whether that word can anyhow be been used actually. Because DearSA does not, according to its own principles that it has set for itself in the beginning, I don't think that it has got the right to influence a certain decision to be made. It should only be a carrier of information between those who comment and government. And let me further go to the website of DearSA. And people, here's the website of DearSA. Now, what concerns me here is that, it says here that they've got a participant network of over 900,000 people. So, in other words, this email that I've showed you that came from them now 2 days back, have gone out to 900,000 people asking effectively for support and donations for their court case. So, Afriforum and Hurter's peace attorneys are utilizing a network of 900,000 people to get benefited from DearSA's network. People, if I have commented on DearSA's platform, I will never have allowed my opinion to be used as statistics for a case that Afriforum is running, or their attorneys. I would have loved my opinion to have been respected and then conveyed to government as it should have been. Not to have been used to attack the government. If you wanted government to be attacked, come to an organization like Liberty Fighters Network and give your support to us, because we are attacking the government for what they have done. We've got principles that we are doing it. We have said so over and over again, that we are not aligned with the government and what they are doing. So people, then there's the other thing. Let's just go and see. This is their platform, and then there's a participation process on there. So you then elect, and let's go, have your say on the amendments to the Health Act. Permanent COVID regulations. Okay, now when you press it, then you come to this point where you give their input. And then you start typing, select your region, select your answer, and there, yes, I do, no, I do not fully. Those are the comments, and you give your comments, you give your names, last name, telephone number, your email, and it's sent. Sounds very much noble. Let me just show you what the media said before. This is an article on News 24, dated the 9th of February. DearSA in turmoil amid allegations that founder abused donor funds. Founder is obviously Rob, but he has never been found guilty of any irregularities. I've stated that before. There's a photo of one of its directors at that point in time, Sandra Dixon. Go and Google her, then you'll know who she is. And the other prominent director at that point in time was Ted Blom, the famous Eskom commentator in public. I understand that both Sandra's and Ted's relationship with DearSA ended shortly after, so they're not directors anymore from what I understand. But what is interesting here is it recently emerged that grant money totaling more than 847,000 Rand was received from a UK-based donor called Indigo Trust. And remember that name, Indigo Trust. And there's another article, DearSA removes Director Rob Hutchinson over alleged financial irregularities. Rob has, as far as I know, not been found guilty of any of those allegations as yet, so his name is clean. But let's just go to the Indigo Trust. Who's the Indigo Trust? So they gave 847,000 rand to DearSA. Phew. Let's just see who they are. And this is so interesting. There's the Indigo Trust. You can go and visit them on their website, indigotrust.org.uk. This is an article written specifically relating to DearSA, dating the 13th of March 2019, promoting political participation with DearSA. And they are saying, yeah, this is what makes DearSA so fantastic. To receive a grant, whereas the South African government considers petitions as a single submission, even if they have thousands of signatures. The method used by DearSA ensures that each and every public comment is counted as an individual submission and must, by law, be considered in the decision-making process. This is why DearSA presents objective campaigns to invite comment, not signatures from all points of view, and delivers each individual public comment directly to government through official channels. Campaigns are launched whenever government gazette an amendment to an existing law, proposed new legislation, or announces tariff increases. But look at this, people. Where did I see? Oh, yeah. Given their track record and innovative approach to public participation in politics, Indigo is delighted to be supporting South Africa continue and expand its work. Our grant of 400,000 ZAR, South African Rand, will allow Dear South Africa to further develop the site, invest in marketing and promotion, and potentially partner with other organizations to further their work. So, people, now in 2021, they referred to a grant of 847,000 Rand received from the Indigo Trust, which they received late in 2020. This 400,000 Rand was made during 2019, according to that article. So it appears as if the Indigo Trust, on a regular basis, puts in a lot of money as a grant for DearSA. But who is the Indigo Trust? And this is not good at all. How we work, and this comes from their website, indigotrust.org.uk, and they say that Indigo Trust, Indigo does not accept unsolicited proposals. Experience has taught us that an open application process is burdensome for both sides and rarely results in new grants being awarded. Through a combination of desk-based research, scoping visits, recommendations from partners, and suggestions from grantees, we identify suitable partner organizations and projects to support. This approach allows us to directly target relevant and high-quality organizations while reducing the burden associated with the high volume of unsuccessful, unsolicited proposals. We regularly review the process to identify potential improvements to the system, and it goes on. So Indigo is not asking people to present proposals and then they decide who will get a grant. So they choose who's going to receive this grant. So DearSA was chosen to receive a total of, according to this information, over 1.2 million Rand in 2 years' time. And what it is, effectively, when you start reading through the whole website of Indigo, then you'll see that they actually, the intermediary between a donor who wants to be anonymous and the recipient. So if, for example, Johan Rupert or the Oppenheimers don't want to attach their name to the EFF, for example, then they make a payment to the Indigo Trust, and then those monies are channeled through the Indigo Trust to the EFF, for example. So this is exactly what has happened then in DearSA's case. A secret admirer of DearSA has deposited money in the bank accounts of the Indigo Trust, and that was then channeled, total of 1.2 million Rand, to DearSA over a 2-year period. So someone really wants DearSA to succeed in whatever they're doing. People, if we receive 1.2 million Rand suddenly from an unknown donor, we'll probably create a in-the-face project to get rid of the incompetent government we've got. With that 1.2 million Rand, we'll surely make people aware of how to get rid of this incompetent government that we've got. and that might even result in Parliament to resign, all of them, and that we can elect new leaders. That is the magnitude of what this amount can do. So what did DearSA really do? Did they use that to print papers, to make boxes so that it can be dumped on the stoop of Parliament? Will that justify 1.2 million rands worth of paper? Yes, we've seen that it's quite a lot. But the fact is that it's so much money that DearSA received that for an organization like us, we would have really done something with that. And by simply being an intermediary between the people and just be the postman between the people and Parliament, people are sorry, I don't get it. I honestly don't get it. And you know, with anyone with a mediocre capabilities of having a website in the fashion like DearSA, anyone can create such a website. It's not difficult, people. It's really with a normal WordPress template, you can easily do exactly the same as DearSA. I don't get it. Sorry, honestly. And let me show you why I don't get it further. And you know, if DearSA was such an organization that really wanted people to start commenting, they would actually give the people the resources with what they actually get, and so that the people can do it themselves and not use DearSA as an intermediary. And for that purpose, I honestly think that DearSA has become a factory for leads, a factory for emails that can, at the end of the day, be bombarded to get further money for what? For Afriforum and her dispute attorneys to fund their court cases. Sorry, people, I don't get it. And let me go to this one website that they don't tell you about. Parliament. There you go. Parliament.gov.za. This is the one that you need to go to get so much information about government. And wow, look at that. Have your say. And when you press it, then eventually you come up with this make a submission on a bill, and it even tells you how to do it, what it is a submission, how to write the submission, guidelines for written submissions, presenting oral submissions, and so on. People, if DearSA is the independent organization without any view, why, and if they really want to promote public participation in the legislative process, which they said from the beginning they are, why don't they tell the people that once a submission is made, you can even ask that you present oral submissions. So very few people know this, and this is something that DearSA should have actually told the citizens in order to promote participation in the legislative process. So nowhere in the commenting platform have they introduced a mechanism whether you want to make an oral representation to the legislature at any given time. So does that then mean that DearSA will be the one going to Parliament to provide that input or that oral submission, irrespective of the fact that 3% of the people were 100% fine with these health regulations, and people, yeah, it's 3%, but it's a comment. They participated in it with the intent that their opinions will be escalated to government. Why those health regulations should come into force. And then the other thing is that there's this wonderful website that is most probably utilized by none other than DearSA to enable them to provide the service that they are rendering. It's called it's www.gcis.gov.za. It's the government communications website, and yeah, I was actually very surprised when I've noted this website in the very beginning, and there's all sorts of interesting information from government, and which appears as if they really want to be transparent in many ways. There's very incriminating information that I got against government on this very website as well before. But I want you to scroll down, sorry, to subscriptions here under. And when you press it, then you get to this website here, or this board. It's all the subscriptions that you can have. It's the tender bulletin, the vacancies alert, it's bid alert, there's a newsletters, and then this is the one that I have subscribed to. Oh, then, okay, there's the SA News. This one I've subscribed to. At 12 noon each and every day, I receive an email from What's New Digest, and then they give me everything that happened the past 24 hours, from speeches and reports and you name it. It's such a nice data service coming from government, believe it or not. And what I want to show you here, this is the one of the 18th of March this year, issue volume 197, issue 18, and you can see here that it's in chronological order. I receive it each and every day. I've created a folder in my email program, and it's automatically, when it comes in, it's automatically sent to this mailbox. But look at this, people. This is the infamous regulations, health regulations we are sitting with, or fighting in court now. This is, okay, it's open for comments, invited. Point 31, and then you just go down the list to 31, and when you press that, then you come to this government gazette. And then it says when it stops, when comments are supposed to be submitted, the addresses, fax number, and even email address of this person that you can send the comments to. People, this is most probably the service that DearSA is using. They probably get this at 12 noon each and every day, and then they go through it, and then they send out the information. Why don't they give this information to the people? If they really want to advance public participation, this is the actual service that people should need. Then you can decide which ones you want to comment on, and then you can follow the processes that's going with the link. People, I've lost track. And then people, the letter. I've sent a letter on the 5th of August to all the legal teams of Afriforum, DearSA, Solidarity, and Sakeliga. Because our cases challenging these infamous health regulations have been handled as one group from the beginning. When the minister on the 22nd of June repealed these regulations, those amendments, Afriforum and DearSA in their case, Solidarity in its case, and also Sakeliga in its case, accepted it as it is. But we went and we said, oh, you wanted to catch us out, and we then went on to amend our papers. And we are so happy that we did do that, because from that, we got the information that the government did not have any information to have backed the repeal of those regulations. So it had to have been a settlement that the minister did in relation thereto. So the minister said, "Oh, but it was a normal legislative process, but and that everyone needs to, now that he has done this legislative process, everyone must withdraw their cases because they have become moot." And then we went after the minister to get that information. So based on that, we got this additional treasure of information that the others don't have in their cases. So what I did was I wrote a letter to these legal teams, and let me read you this letter. It's to Spies, to Serfontein, Viljoen Swart, Kriek, Wassenaar, Venter, and it's in relation to various cases against the Health Minister, inclusive of our matter, and that's the reference. And yes, it was on the 5th of August that this was sent. And the basis of this was basically that each matter proceeded as the parties deemed fit, but have reached a point where all of us have to discuss a way forward. The main question is, will each one proceed on its own, or will all matters be heard at the same hearing? Now, Reyno is concerned that if each party proceeds on his or its own, that the risk of conflicting judgments could ruin the outcomes in other matters too. Thus, Reyno would like to address the possibility with you that all cases continue to be heard together, where the possibility of cross-referencing to other cases are then feasible. For example, and this is very important, that, for example, the applicants in our specific matter proceeded to amend their original case to such extent that the Health Minister has now failed to produce the records for both the draft health regulations and the decision to repeal the amended health regulations on the 22nd of June. The logical inference was for us to have proceeded in supplementing our application as if there was no record, when the Health Minister was reprimanded to deliver and subsequently failed. This failure by the Health Minister can therefore also benefit your respective cases too, by, inter alia, confirming that the repeal was a settlement and not a normal legislative process, making all of you entitled to costs. And then we have proposed a timeline to be followed. And this is very important. Your kind response by no later than Friday, the 12th of August, will be highly appreciated. In failure, the applicants in our matter will proceed with their case as they deem fit. Well, people, we've given our cooperation with all these others to say that, even if we don't have the same ideals for our organizations, this is the time that we need to sit around the table and think about the best interest of the public. So let's let our cases proceed simultaneously or at the same hearing, on the same date. That way we can cross-reference to one another's case, and you can utilize stuff that we have produced in ours and vice versa. People, we haven't received any response from, inter alia, DearSA. DearSA did not want that. They decided that no, the Liberty Fighters Network, we don't want to cooperate with you. We will proceed on our own, and we don't care if we can't use some of your information because our outcomes have already been decided. We already know what is going to happen, and you are just an intrusion. So we don't want you to put a spanner in our works, which this appears to be. So why would none of these solidarity-related organizations want to have the same hearing as the one for Liberty Fighters Network? Why not? People, let me go back in history to the end of 2020, and this is so in the face of DearSA. Sorry, I've been my remarks have become a cliche, but this is the case 60279. This was way back in 2020. And there important here is that it's DearSA, the applicant, and Minister of Cooperative Governance, respondent. Okay. Now, what happened was that DearSA lodged this application against the one extension, or the extension that was published on the 13th of November 2020. They wanted to review it and set it aside and be declared as unlawful. So DearSA was the applicant, the Kokta Minister was the respondent, and so at that stage our appeal was still to be heard by the Supreme Court of Appeal. So we couldn't join as a party, but we then lodged an application to become an amicus in that very matter. So it meant that so I've then applied to be a friend of the court, so that I can convey what has already transpired to court, because the court was not aware of it. So I've applied to become an amicus, and at that stage, the organization Panda, let me go to that one. Notice Panda, they also wanted to be an amicus in that very matter. Panda, Knowledge Factory, MPC, against DearSA and so forth. And they have been represented by Werksman's attorneys, the attorneys for the South African Reserve Bank and other major banks in South Africa. So Panda clearly had to pay a lot of money to them. Suddenly, out of the blue, DearSA decided to settle the matter. They had an extremely wonderful case, but they decided to settle it with the government. And but something very strange happened here during those negotiation phases. Strangely, the Minister of Health became the second respondent. People, anyone that knows the uniform rules of court will know that if you want to join as a party to the proceedings, you need to make an application to be joined as, in this case, a second respondent. So the health minister had to make an application to court to say that I will become the second respondent. And people, when you go here, the notice to oppose was only filed, respondents' notice, it was only for the respondents, for the Minister of Cooperative Governance. There was no notice to oppose even lodged for the Minister of Health. So how he suddenly became a party to the second respondent in the matter, I tried to get answers from DearSA afterwards, but I could find none. They refused to provide it to me. And the order that was subsequently made, which was a total fallacious order, I must say, it was done by Judge Mabuse. Judge Mabuse is a very, I don't like him at all. Now suddenly there's a second respondent, Minister of Health, and by agreement between the parties, it's ordered that the matter be removed from the urgent roll. I'm okay with that. The applicant withdraws his application, each party to pay their own costs. Never in my 28 years involved in law and court cases have I ever seen that a judge orders a party to withdraw its application. I've never seen it. It's a dismissal. It's a scratch from the roll, and then the party just files a notice of withdrawal, but never in an order. The court does not have the jurisdiction, according to me, to order a party to withdraw its application. It should have just been removed from the roll, each party to pay its own cost, and then afterwards the party must then file a notice to withdraw, not make it part of of an order. Such an order cannot be made. Sorry, it cannot be. But very interesting. I just want to show you this. Who the counsel was for DearSA. It was Advocate Mark Oppenheimer. Whether Mark Oppenheimer is related to the infamous Oppenheimer family, I unfortunately don't know. Maybe some of you might have the information, but I don't. And then you will see that the Minister of Cooperative Governance was represented by none other than Advocate Murani, Senior Counsel, and then for the Minister, second respondent, and I don't know still how he could have become a party without a proper application, Advocate Hilton Epstein, Senior Counsel, suddenly approached the scene. More and more I've seen this the past year or so, that senior counsel appears to have the power these days to be sent to court proceedings, to give instructions to judges. Yes, people, because a judge would never have, a competent judge would never have given such an incompetent court order if there was not other reasons for that. So any judge would know that you cannot make such an order. And I've approached Panda afterwards to say whether they're happy with it, and they also never received any response, or apparently they never received any response from DearSA's attorneys or from DearSA why it happened, because they apparently they were also ready to lodge their to proceed to be amicus. And well, people, this is the conclusion of how, or my experience with DearSA. Now you can say what you want, but at least I've spoken my mind. I've given my opinion of what is currently busy, my observation of events, and there's a lot of explanation that DearSA must do. So hopefully, maybe Rob will come out and make a nice statement and tell the people why they supporting or why they involved with heritage speech. Firstly, the attorneys of Afriforum, and why are they together with Afriforum, and why are they not telling in their emails to the people when they ask for comments and donations that Afriforum is part and parcel of their application, and we want to know whether any of the monies that the public donated to DearSA for the court case that they are involved in, whether that is only for DearSA as part of the legal costs, or do they fund Afriforum as well? Because it appears as if Afriforum has started to lose a lot of supporters. People have started seeing through them, and now they could have approached DearSA under possible deceiving reasons to be their financier by utilizing the 900,000 database of people. This is something that needs to be shared. As I said in the beginning, I honestly don't care whether some supporters might stop supporting us. This is not something that Liberty Fighters Network wants to be greater than another organization, but this is where I draw the line. I cannot proceed seeing that the full truth is not shared with the people of South Africa, and I dare DearSA to send out that email that you've sent out a couple of days before, to include specifically Afriforum as the main applicant in it, and see whether you're going to get any more donations that now that Afriforum is connected to your case. People, like this channel. If you want to share this information, consider becoming a member of this channel. Until next time, God bless.
Liberty Fighters Network.
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 Liberty Fighters Network.